All right, lawyer talk off the record on the air, sitting here at the round table. You would wonder why there's two of us here. I will get to that shortly. Steve Palmer here, lawyertalkpodcast.com, where you can go submit your questions, give us your comments. If you want me to cover a topic, just let me know. The questions, the comments, things are flooding in, so we do appreciate it. All sorts of other back episodes there too. Check them out. I have been doing this Q&A series where I answer people's questions that phone in or that email in. And, it dawned on me is that I've got Troy here. Troy's a law student at Capital University.
Yes.
Capital University Law and Graduate Center, second year about to start for you, right?
Yep, start next week.
So a second year law student. Now, Troy's been working for me over the summer as a, quote, law clerk. So anybody who's ever heard that term, really what it means is some generic description of a law student who's working for a lawyer over the summer.
That's accurate.
Yeah, doing research, clerical work. I look at these as teaching opportunities. I love to teach, and I try to help my law clerks out, not only in their career professionally, figure out where they want to go, but also teach them what I know. And believe it or not, what they're teaching in law school may not always apply in the real world. It gives you a foundation to go learn what the real world is all about, but it doesn't always teach you what exactly is going on. And it dawned on me when Troy is asking me questions when we're talking about cases upstairs, it's a lot like what I do on the podcast Q&A. So every now and then you're going to see Troy at the table asking me questions, and maybe we'll do something more with it at some point. But there was a question you had the other day that I thought was well worthy of a discussion down here at the podcast table. So why don't you go ahead and shoot?
So I was reviewing an appeal, and it was talking about how...
All right, so an appeal, what he's doing is he's reading a decision by a court of appeals on a case that somebody was convicted of a crime and later went up to the Court of Appeals, and the Court of Appeals wrote a decision either saying, yay, the conviction was accurate, or the conviction was correct, or the law was followed, or nay, we send it back, do it right next time.
That's correct. She was facing an issue that I see all the time online where the police come up to her and they start asking her questions.
So online, you mean like TikTok?
Yeah, TikTok.
So he's on the TikTok, he's on the YouTube, and, there's a whole generation of these. And they're probably like, what, little 10, 15-second clips where, what do you do when a police comes up and asks you for your identification? Mm-hmm. A lawyer has the answer.
Yeah, we call it brain rot, is just falling into
brain rot, doom scrolling.
Yeah. And so the police come up to her, they're asking her for identification and everything, and she's not complying with them. She's like, here's my first name. And in return, they charge her with, I believe, it was some type of charge saying
obstruction of justice. Obstruction of official business.
Failing to disclose information in violation, and then list the Ohio Revised Code.
All right.
And so then she has a bench trial over this issue.
So bench trial, let's break it down. Mm-hmm. So a bench trial, some people have jury trials, some people have bench trials. What's a jury trial? On a misdemeanor offense like this in Ohio, that means 8 jurors sit in judgment of the facts of the case. In a bench trial, sometimes the lawyers will say, or the litigant will say, the defendant, I don't need a jury trial. I'm going to let the judge figure it out. So you're going to try it to the bench. And literally the judge is sitting on the bench, and that's why it's called a bench trial, not a jury trial.
Mm-hmm. And so she loses the bench trial, and then she's...
Hold on a second. So there's more there. Why then would you ever want to have a bench trial instead of a jury trial? Well, that's a good question. If you don't have a good answer to it, and your lawyer doesn't have a good answer to it, then you probably want a jury trial. But sometimes there is a good answer to it. And this case is one of these times, because this is already, I know, this is something that in my head I'm thinking this is a legal issue. And sometimes the legal issues sort of overlap with the factual issues. So like if the issue was this assault in self-defense, or did somebody really do something? Well, typically you want a jury for that. But sometimes it's like these quasi-legal issues. Like if a police comes up to me and asks me for my identification, can I say no? And is it a crime if I don't? That's going to require a certain legal finding before you can make the factual finding. And that's why I believe already that this was a bench trial. See what happens when you practice law for like 30 years? Anyway, go ahead.
And she loses the bench trial.
Nobody taught you that in law school.
No, they didn't. And she loses the bench trial, and now she appealed it. And the whole reason that the cops were there was because allegedly her dog bit a neighbor's kid.
All right. And so the cops come up to her on the street or in her house?
On her porch.
On her porch. So the cops approach. There's somebody called the police and said, that woman's dog bit my kid. Mm-hmm. Police come up to the house and they want to talk to the girl.
Yes.
What does the court say?
The court said that, yes, in a criminal matter, she does have to provide this at least her last name, other forms of documentation, all that. However, this was not a criminal matter the courts determined. This was a civil matter, which in my head, if your dog bites somebody, I would view that as criminal. But they determined this was civil and she didn't have to disclose any of that.
All right. So the court says this woman was convicted at trial by the judge
Mhm.
of failing to provide identification in some sort of investigation, whatever nonsense code that is.
Mhm.
And it goes up to the Court of Appeals. Court of Appeals says, nah, because this is a civil case. It's not a criminal investigation. Therefore, that statute doesn't apply and you don't have to supply identification. This is like a huge iceberg under the water, right? This is like the tip of the iceberg of a huge constitutional issue. And anybody that is older than you will remember back in the 80s, a guy named Rudy Giuliani. You know the name?
Yes.
All right. So Rudy he was the uh, United States attorney in one of the New York districts, and he comes in and he becomes the mayor of New York, and he's going to clean up the streets. So he starts creating all these sort of stop and frisk laws or stop and identify laws, and these are all over the place. Lots of states have them. And the issue is, can the police just come up to any general citizen and say, identify yourself? And as you might expect, the U.S. Supreme Court has weighed in on this. And basically, here's how it shakes out. If the police are investigating a criminal case and they have something called reasonable suspicion to investigate. Now, what is reasonable suspicion? Sort of like pornography. I can't define it, but I know it when I see it. But the Supreme Court defines it as a reasonable or articulable suspicion that criminal activity may be afoot, which is fancy talk to say they think something's wrong and they can actually point to a few facts, as opposed to, quote, an inarticulate hunch. That's not reasonable suspicion. Again, what does all that mean? I don't know, but you know it when you see it. So if the police have reasonable suspicion and they're investigating a crime, then those stop and identify laws have been upheld, where they are just asking somebody, sort of in the context of a civil case, for instance, hey, I want your ID. I want you to tell me who you are. And you say no. Well, they can't punish you for that. They can't make it a crime. And this comes up all the time. So it's not just that you have a constitutional right to say no, it's that the government can't punish you for exercising a constitutional right. So that becomes the violation. Or if you're chilled based upon some law or some activity or some conduct by the government from exercising your right, that can become a constitutional violation as well. So underpinning all of this decision and all these laws is this constitutional notion that the police can't just stop and frisk anybody on the side of the road and ask them for identification. Those laws, by and large, when there is not reasonable suspicion to investigate some crime, have been struck down as unconstitutional. And that's why this case came out that way. I haven't read the decision, but I would almost guess that underpinning all of this is that logic. Now, that's the legal side. There's the practical side to this. If you think, and people have heard me say this all the time, when you're engaged with the police, when you have the police knocking on your door or staring at you through your driver's side window, guess what? They got the badge, they got the gun, they got the handcuffs, and they have the power to put those handcuffs on you, drag your ass to jail, and charge you with crimes. I'm not saying that's right. I'm not saying they always do that correctly. And I'm not saying they might not be flat out wrong and unconstitutionally arresting people. But the point is, don't make a mess out of something that doesn't need to happen. Don't be controversial just because you can. On TikTok, you see all these idiots like cracking their window. What's your name, sir? I don't have to tell you anything. Well, guess what? You don't. But it's like you're not also going to go up to a guy on the street who's twice as big as you and say, hey, go screw your mother. I'm allowed to say that. Like you are, but there's a practical side to this. Now, there are certain people that just like to be antagonists to go make a point. And I suppose activists might be the right word for that. If you didn't have people challenging the bounds of things, if you didn't have people doing that, then the law wouldn't emerge and we wouldn't have these rights. But you don't want to be that person. You don't want to play law student when you're pulled over and say, you're not allowed to pull me over because blah, 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 blah. Well, guess what? They don't give a crap. They're going to put your ass in handcuffs and take you to jail. Now you got to call me to help fix it. And it's going to cost you thousands of dollars to defend yourself. If this gal would have just identified herself, because why not?
Mm-hmm.
None of this happens. None of it. She never gets charged with a crime. She never has to pay for a lawyer. She doesn't have to decide whether to have a jury trial or bench trial. She doesn't have to lose the trial, go all the way to the Court of Appeals, have the case reversed, only to come back down and be right back where she started, when all she had to do was say, yes, I'm Jennifer and I live here now. The next question she doesn't have to answer. Did you let your dog out? Now she needs to say, I'm not going to answer that question because I have a constitutional right not to incriminate myself. Giving her name was not incriminating. Identifying herself was not incriminating. Sometimes it is. This time it wasn't. And that's why all this happened. Easily could have been avoided.
Absolutely.
They didn't tell you that in law school. So,
No.
all right. Steve Palmer here, lawyer talk, off the record, on the air, taking the law school questions and educating the public with them until now. Hey, Steve Palmer here from Lawyer Talk. Thanks for listening. Hope you enjoyed it. Check us out, all our social media. Like, share, interact, ask your own questions. We're here for you.